Okay. Hello, everyone. Thank you so much for joining for this first Young AfAA webinar. My name is Sylvie Beboyi Ebongo. I am an AfAA board member, and I'm very happy to be the one to lead this first webinar. So I will be presenting what is the Young AfAA, and then I will hand it over to Karim, who will be leading the conversation today with our speaker, Jerry Kariuku. First of all, let me present then the Young AfAA committee. The Young AfAA committee was created 2 months ago, and it is a networking and knowledge sharing group for AfAA members belonging to the 35 years and under membership level. The Young AfAA committee aims to share experiences and knowledge in international arbitration, alternative dispute resolution, encourage peer-to-peer learning, and grow the Africa International Arbitration ADIR community. To achieve the above aims, Young AfAA committee has decided to hold virtual meetings once or twice a month, depending on the needs, interest, and motivation of Young AfAA committee members with whoever joins. Members will either volunteer or be approached in advance to deliver a brief presentation or to participate as today on an interactive webinar about an issue they encountered in their practice or a soft skill they wish to share in either international arbitration or ADR. Attendees will participate by asking questions or commenting on the chat. It is important to notice that virtual meetings can also be held by non-AfAA members willing to discuss a relevant subject in international arbitration and ADR. We encourage you, therefore, to join the virtual meeting and invite you to volunteer, deliver either a 30-minute presentation specifying what you would like to speak, or to organize an interactive webinar in the language of your preference, English, French, Arabic, or Portuguese. Currently, the Young AfAA committee is led by myself and Dr. Sally Sawa, Deputy Secretary General of AfAA. We are therefore pleased to launch this first AfAA webinar, and we hope you will be joining the Young AfAA committee and be the next to participate to a webinar or to deliver a speech. Send us your interest. I will be putting the address in the chat. Our first Young AfAA committee webinar will focus on a highly topical subject, the case for and against the use of dispute boards. As many of you know, dispute boards are a common structure of construction projects and undoubtedly have significant benefit in resolving and even avoiding disputes. However, it is not uncommon for dispute board to become mini arbitrations, which is, in the view of some, serve to increase delay and cost. In this seminar, our speaker will share their own experiences of how dispute boards have worked well in practice, and will posit suggestions on how might avoid some perceived as the downside of dispute boards. Without further delay, it is my pleasure to introduce our speakers of today. The first and not the last is our Young AfAA member, Mariam Curry. And I would like especially to thank Karim for having taken the leadership in the organization of this webinar. Thank you very much, Karim. Karim Mari is an associate in the London Construction and Engineering Group of White and Case LLP. He advises owners and contractors on the resolution of disputes arising out of international construction and engineering projects, with a particular focus on projects in Africa and the Middle East. Karim's experience spans litigation, arbitration, dispute board proceedings, and mediation. Karim is a native Arab speaker and is qualified to practice in England and Wales. Karim is regularly invited to speak on a range of construction law and ADR topics and has contributed to various articles and publications, including a commentary on the Untitled Model Law on International Commercial Arbitration. We are very happy to have you, and we are lucky to have you for this topic because you are one of the young leading practitioner on the subject. Karim will be discussing this interesting subject with Mrs. Njeri Kariuku. I must say that Njeri needs no introduction because she is one of our leading practitioners in the continent, in the field. But I will try to summarize CV. Njeri is an advocate in the High Court of Kenya since 1988. You can understand how long she has experience in this field and in the topic we will be discussing. She practiced from Nairobi, Kenya, and described herself as an advocate turned dispute resolver, having found quite early in her career a passion in ADR. Njeri now sports the additional heads of chartered arbitrator and accredited mediator. Njeri is a fellow of the Chartered Institute of Arbitrators, has been recognized since 2014 to date as a leading individual by Chambers Global. She's a government of Kenya nominee to the panel of arbitrators at ICSID. She has been appointed since 2018 as ICC International Court of Arbitration member, and she has been reappointed in July 2021. She is recognized as one of the top 13 African arbitrators in early 2021, and she is a great believer in giving excellence in service. Whatever you do, do it well. So I have no doubt that Njeri will really do it well as she often does. I will now hand it over to Karim, who will cover the first topic, and he will be discussing with Njeri. Last but not least, please use the chat to ask your question on the topic, because that is how you build your career in international arbitration. That is how you learn and you enforce your building capacity. I will now hand it over to you, Karim. Thank you, and we will be having you at the end. Karim, the floor is yours. Thank you very much.
Thank you, Sylvia, for that very kind introduction, and thank you to those who have joined us today. Before we get into the nitty-gritty of the case for and against dispute boards, we just wanted to set the scene and give a general introduction of what dispute boards are and the different types of dispute board. At its core, a dispute board is a panel of usually 1 or 3 dispute board members who are appointed by the parties to a contract to resolve and or to help avoid disputes. It's often said that dispute boards are creatures of contract. A dispute board is put in place by agreement of the parties in their contract. The powers of the dispute board are delineated in the contract, and the consequences for not complying with the decision of a dispute board are also set out in the contract. And one can contrast this, for example, with statutory adjudication in places like the UK, where it's subject to applicable statutes, as the name suggests, and even with arbitration, which to varying extents is subject to and governed by the laws of arbitration in the place of arbitration. And because they are creatures of contract, dispute boards can take many forms. There is the standing dispute board, which is constituted shortly after signature of the contract and remains in place until the contract comes to an end by completion of the work or otherwise. But alternatively, we see ad hoc dispute boards, which are constituted to decide a particular dispute, and their appointment comes to an end when they issue their decision on that dispute. The powers of dispute boards also vary. Some dispute boards are only empowered to issue non-binding recommendations, which the parties are free to do with as they wish. Others are empowered to issue binding decisions, with, like I said, the binding nature of those decisions being specified in the underlying contracts. Some dispute boards are even empowered to have a dispute avoidance function, where the dispute board is involved throughout the project and assists the parties in identifying and resolving issues before they escalate to becoming claims or disputes. Now, the dispute board procedure is intended to be quick and cost-effective. The dispute board is usually required to issue its decision on a dispute within a short period of time from the date a dispute is referred to it. And the idea behind this is that dispute boards are dealing with disputes on ongoing or live projects, and by resolving disputes quickly, they prevent disputes from holding up those projects. Now, you will have heard me refer to work and projects, and that's because dispute boards have really become a feature of many construction projects, no doubt because construction projects, for reasons which require a separate seminar, can often be fertile ground for disputes. Indeed, popular standard form construction contracts provide for and envisage the use of dispute boards, including the FIDIC forms. Now, interestingly, whilst the 1999 FIDIC forms of contract provided for what is called a dispute adjudication board, the 2017 FIDIC forms now provide for a dispute avoidance / adjudication board, with the 2017 contracts including provisions allowing parties to seek informal assistance from the dispute board to help them avoid disputes. And I think that's a reflection of a trend that I'm certainly seeing in my own practice, with parties keen to use dispute boards to help avoid the time and money associated with other methods of dispute resolution. And on that, Ms. Karaoke, staying with the theme of dispute avoidance, I'm interested to hear whether, and if so, how, you think dispute boards can really help parties avoid disputes.
Thank you, Karim. And let me just say that's a great pleasure to be sharing this platform with you. Now knowing that you are so well versed in your field, thanks to Sylvie's introduction. In my experience, dispute boards work very well, especially when you have a standing DP that regularly visits the project and interacts with the parties. Their purpose is to help the parties identify and avoid potential disputes. I have also seen non-binding recommendations issued by DBs on questions of contractual interpretation to help avoid disputes. Just harking on what you've already said, Karim, the main purpose of dispute boards is to prevent disputes, which is called dispute avoidance, and which you've already alluded to, contained in the 2017 FIDIC rules. Under FIDIC, this DAAB, you've called it a DA/AB, but it's a combined dispute board, or CDB, and therefore serves both the purposes of ensuring there's avoidance and also to give any decisions under adjudication. So it stands for everything now. It's allowed to do everything. I guess that's why the name was expanded. To resolve disputes also that have arisen, and the standing dispute boards are able to resolve such disputes promptly, because having made several site visits and being present pre-contract or right at the outset of the contract, they are conversant with the project. So it doesn't take them time. I mean, you can consider looking at arbitration and seeing how long it takes to write an award As you well know, with adjudication, it's 30 days, or as stated in the FIDIC rules. I know I've seen one that I think our local one was, it's a while back now, but I think I saw 83 days. But anyway, there's a stated restricted time within which that adjudication decision must be given. So another purpose of dispute boards is to prevent, to see how far they can prevent a dispute actually even evolving, because their minds are so well focused on the whole project that they are able to see something evolving, and they snuff it out even before, you know, when it's merely an ember. So such a role falls under the DRBs and also these, what we've called a CDB, or Combined Dispute Board. Generally, let's say that dispute avoidance is possible with standing dispute boards, where the dispute board is set up during the pre-construction phase, which is what I've just referred to, and it is present throughout the course of the project. I know some parties get unhappy, become unhappy and want to disband them, but you know, where the contract so dictates that dispute board is going to remain the whole time to the end of a project. The members of the dispute board make regular site visits, I also alluded to that, and they regularly, in addition to that, receive progress reports to keep themselves abreast with the status of the project, whether these are the progress, whether there have been any changes, whether there are any claims that have arisen, and of course any problems that may have cropped up. Now, how is dispute avoidance achieved? This is three main ways that I'm aware of. The mere presence, number one, that the DB visits the site regularly, causes the parties to be more objective when discussing any issues that they may have any difference over, knowing that if they do not agree, the matter can easily be referred to the dispute board, who would be available to deal with it at an instant. Well, not an instant, but they'll be available within the shortest time possible. The parties are therefore more likely to agree and resolve their differences and prevent the difference developing into a dispute. During the regular site visits, this is number two, the dispute board is able to identify problems and areas of concern. And of course, you have meetings with the contractor and the representatives of the employer when you visit the site, which could possibly develop into disputes if not resolved. The parties are then able to focus their minds on those matters and endeavor to resolve such before they can develop into disputes. Thirdly, when the parties are unable to resolve any difference between themselves, the matter may therefore be referred to the dispute board for its opinion or non-binding recommendation, both of which have to be in writing, so as to convince the parties of the wisdom of the dispute board's solution. The opinion or recommendation also gives the parties an objective view of how the dispute may be perceived by other third-party fact finders, such as arbitrators. In most cases, the parties accept the dispute board's opinion or recommendation, and hence the matter is resolved before it develops into a dispute. Let me ask you a question, Karim. Have you come across instances where a dispute board may have, at the outset, appeared to be appropriate, but on account of the magnitude of the project and the fact that the parties may regard dispute adjudication board proceedings or any of the others that we've already named to be a waste of time and money? There are people who hold this perception that the inevitability of going to arbitration is obvious, because this is the preference of the parties.
Yeah, thank you, Ms. Karaoke. I certainly have come across those types of instances. And like you said, I've often heard critics of dispute boards say that dispute boards aren't the right forum for resolving very large and very complex disputes on very large and very complex projects. But I still think that dispute boards serve an important function in respect of those disputes. So imagine a scenario where you have 3 years of delay, hundreds of millions of dollars in claims, lots of complex technical and legal issues, and the relationship between the parties is so acrimonious that they're basically unable to agree on anything. And it sounds extreme, but as those of us who work on construction projects regularly know, it's not an unusual scenario. Now, referring a dispute of this size and complexity to a dispute board can result in one of two things happening procedurally. One, the dispute board sticks with what I will loosely call normal dispute board procedure, with, as you said earlier, the dispute board's decision being issued within a short period of time, which means limited or no witness and expert evidence being tendered, no cross-examination at hearings, etc. Or, having regard to the size and complexity of the dispute board and the parties extend the time period by which the dispute board has to render its decision, and the parties are allowed to submit fact and expert evidence, witnesses are cross-examined, and you have lengthy submissions with thousands of exhibits being filed. Now, in the first of these two scenarios, whatever the dispute board decides, the losing party will be dissatisfied. And it may take the view that it would have a better chance in arbitration where it has the time and procedural scope to tender all the evidence it thinks it needs to make out its case. And so that losing party will almost inevitably refer the dispute to whatever the next tier in the dispute resolution mechanism is. In the second of these two outcomes, the dispute board procedure ends up being, as you said, a mini arbitration or litigation with all the associated delay and cost. And still, the losing party, given the significant amounts in dispute, may well think it wants to try again by referring the dispute to arbitration or litigation, meaning again, more delay and more cost. And I think it's with this scenario in mind that critics say dispute boards may not always be the right forum for resolving all disputes. But like I said, referring a large and complex dispute to a dispute board still, I believe, serves some important functions. So, for example, the dispute board procedure may not finally resolve all the disputes, but it may narrow the issues between the parties. Also, especially for contractors, dispute boards can help provide a very important cash flow lifeline. Yes, the dispute board's decision may be referred to arbitration, but often contracts provide that the parties have to comply with a decision of a dispute board unless and until it's revised by the award of an arbitrator. So if you're a contractor who claims $200 million in costs, and the dispute board awards you even $100 million, assuming the employer pays, getting that money quickly, even if it's on an interim basis, instead of having to wait 2 or more years until you receive an award of an arbitrator, may be crucial for your cash flow. So overall, I think the case for dispute boards, even in dealing with very large and complex disputes, on balance outweighs the case against them. But I think a separate question regarding the suitability of dispute boards for all types of dispute arises in the context of terminated contracts. I said earlier that really the ethos, at least in my view, which is at the heart of dispute boards, is that they resolve disputes quickly so as to allow the parties to get on with the project. I've heard it being called comply now, argue later, or pay now, argue later. But in circumstances where the contract is terminated, that ethos is no longer relevant because it's not possible for the parties to get on with the project. In that scenario, I can see an argument being made for doing away with the dispute board procedure and allowing the parties to directly refer their disputes for final resolution by arbitration or litigation. And I think this argument is supported by the fact that when a contract is terminated, the relationship between the parties is completely broken down, such that it's probably unlikely for a dispute board to facilitate settlement, to avoid disputes, or indeed to do anything but delay the inevitable arbitration proceedings. So I wonder whether parties need to think about, when they are putting in place their dispute board procedure, saying in their contracts that if the contract is terminated, then the appointment of the dispute board is also terminated, such that disputes can be referred directly to arbitration or litigation. And I'm not expressing a view as to whether this is a good idea or not, but I'm interested to hear your thoughts on this and the others on the call during our Q&A session at the end. Now, Ms. Kariuki, I alluded briefly to dispute boards helping parties narrow issues in dispute. And I'd like to hear how, in your view, this works in practice, especially having regard to the fact that you've sat as a dispute board member.
Thank you, Karim. Yes, I did rather enjoy that stint as the chair of a DAB. It was a most exciting period for me, doing something out of the mundane and ordinary. Now, let me see. I think that even where a party does not accept the DB's decision and the matter has to proceed to arbitration, it is more than likely that the parties would already have accepted the dispute board's conclusions on a number of issues, so that ultimately only some of the issues are referred to arbitration. That's one way that the issues heading to arbitration will have been narrowed. Secondly, or in addition, the dispute board's decision helps the parties to see the strengths and weaknesses of their respective positions on the various issues. In that way, they are then more likely to agree on a number of the issues that there's been any difference upon, and hence narrow the issues that remain live. That is actually one thing that I saw with in fact, in my dispute board, the parties were actually very cooperative. That's my recollection. And when we finally did have to give an adjudication or a decision, it was accepted. It was accepted. We had worked slowly with the parties to fruition of that project. And in fact, it proved to be very successful and accepted by the employer ultimately. So there was we didn't have any real problems. But Karim, I'll be frank with you. One of my pet peeves is the manner in which dispute resolution clauses are drafted by both in-house lawyers as well as commercial lawyers. It is we, the dispute resolvers, who then have to deal with the fallout from what we refer to as pathological dispute resolution clauses. And I am of the view that it would be of assistance if greater care was applied in this regard. What's your view on this, where dispute avoidance or adjudication boards are concerned?
I said at the start of the talk that dispute boards are creatures of contract. And I think that's another point in favor of dispute boards, because it means the dispute board mechanism is exceptionally flexible. The parties have almost complete freedom to craft the dispute board procedure which is right for their project. But like any creature of contract, the procedure only works as well as the drafting does. And I talked earlier about how dispute boards can help alleviate cash flow concerns for contractors. But that benefit only materializes if the contract clearly provides the decisions of a dispute board are binding on the parties, even if it is on an interim basis. Also, often we see dispute boards in multi-tier dispute resolution clauses, with disputes being referred to a dispute board, and if either party is dissatisfied with the decision of the dispute board, they can then refer the dispute to the next tier of dispute resolution, which is often, but not always, arbitration. But are the parties required to refer a dispute to a dispute board before the tribunal has jurisdiction to decide that dispute? In other words, is a dispute board decision on a dispute a precondition to arbitration? Now, that's one area where I, like you, Ms. Kariuki, have seen drafting become an issue, because The answer to the question I posed is it depends on the wording of the dispute resolution provisions of the contract. And if it's not addressed clearly, you can find yourself in a situation where jurisdictional objections, admissibility objections are made before tribunals, with one party saying, well, I wasn't required to go to the dispute board before availing myself of arbitration, and the other saying that the dispute board procedure is a mandatory precondition. And all this does is delay the final resolution of disputes and increase costs. Another area where I've seen drafting of dispute board provisions give rise to issues relates to notices of dissatisfaction. Now, often contracts provide that if either party is dissatisfied with the decision of a dispute board, that party must issue a notice of dissatisfaction within a specified number of days. Otherwise, the relevant decision of the dispute board becomes final and binding. But what if I'm a contractor who was awarded a full extension of time by the dispute board, but no prolongation costs on account of, for example, concurrent delay? I'm not dissatisfied with the finding on the extension of time. Indeed, I'm delighted with it, but I am dissatisfied with the finding on prolongation costs. Can I issue a notice of dissatisfaction with only the part of the decision that deals with the prolongation costs, or is it an all or nothing notice of dissatisfaction? Well, again, it depends on the drafting of your contract. And if that drafting isn't clear, you find yourself in a situation where a party says, part of a decision is final and binding, and the other says, no, the whole thing is final and binding, or the whole thing isn't final and binding, thereby adding to the disputes and disagreements between the parties. So overall, yes, the drafting dispute resolution provisions can give rise to very interesting challenges with respect to the manner in which the dispute board operates, but many of those issues can be avoided with clear drafting. Now, moving on to discuss enforcement of dispute board decisions. Ms. Kariuki, one criticism that's sometimes levied at dispute boards is that the decision of a dispute board, even if it's said to be binding in the contract, can be very difficult to enforce against a non-complying party. Do you think that that is a fair criticism?
Arim, I think I have to say that I differ. After all, why then does the procedure allow for a reference to arbitration? Let me back up a little to note that enforcement of a dispute board decision normally follows the rules and procedures under which the dispute board was initially formulated. Just as you said, it's the provisions of the contract, the manner in which that dispute, which is where it draws its mandate. The dispute board draws its mandate. So the manner in which is what you've just been saying, is that clause is drafted is what then will give strength to that ability to enforce. Just as I've said, as with arbitration, the dispute board's powers arise from the contract. So generally, the parties have agreed to abide in that contract by the dispute board's decision, normally. And where there is failure to comply, where there's been a breach in better English, a breach of the agreement, a contractual remedy is followed, which is generally enforcement through arbitration. Okay. Now, some of the challenges that may be faced with regard to enforcement is as follows. It is important that the decision is in respect of a dispute that has crystallized. Why? If you look at the clause 20.4 of the FIDIC conditions of contract, it reads as follows. If a dispute of any kind whatsoever arises between the parties, ... either party may refer the dispute in writing to the DB for its decision. So, in the absence of a dispute, since it's very clear from that clause, the DAB does not have jurisdiction to make a decision, and therefore there can be no dispute capable of enforcement. That must be clear. What else could railroad enforcement? How about jurisdictional problems? Besides the question of existence of a dispute, jurisdictional problems that can affect enforcement may be in play, such as validity of the appointment and scope of dispute, okay, which is mandate again, and the like. Okay, so in assessing whether or not enforcement is possible, these have to be taken into account. In addition, how about issues relating to natural justice? There may be a challenge to enforcing any decision that is tainted by a breach of natural justice. Okay, so that needs to be taken into account as well. Now, let's look at the wording of the contract's enforcement procedure. Could that not also pose a challenge? You remember that I did put this to Karim already on one of my pet peeves. What does the same 20.4 clause 20.4 of the FIDIC conditions of contract 1999 edition provide? It notes, the decision shall be binding on both parties, who shall promptly give effect to it, unless and until it shall be revised in an amicable settlement, which could come about, because the parties are really on, they're cooperating with one another. There's some level of consensus, or there has been throughout the project, or an arbitral award as described below. If either party is dissatisfied with the board's decision, then either party may give notice to the other party of dissatisfaction. If the DAB has given its decision and no notice of dissatisfaction has been given by either party within 28 days, then the decision shall become final and binding. So that's the 1999 edition. Okay. So what problems has it posed? Where a decision has become final and binding, clause 20.7 provides that where a party fails to comply with the decision, then the other party may refer the decision to arbitration for enforcement. However, where the 1999 edition provisions have been unclear on enforcement of decisions that have not become final, this has given pause to challenges to enforcement of such decisions. Now, in rights clause 21.7 of the FIDIC conditions 2017 edition, it has resolved that challenge by providing that where either party fails to comply with the decision, whether or not binding or final and binding, then the other party may refer the failure itself to arbitration for enforcement. So any loopholes now have been closed, okay? And parties would be wise to choose the 2017 conditions, so the FIDIC conditions of contract.
Great, thank you, Ms. Karaoke. Well, I think that takes us to the end of our allotted time. So I don't know if anyone else on the call had any questions or observations or anything they wanted to share. Otherwise, we can bring things to a close.
We have a question on in the chat, Karim, maybe through you and Jerry. Mario is asking, what is the background and experience of the people appointed to the dispute board?
Yeah, Ms. Karaoke, did you want to take that question?
As well as I can. It's my experience, or at least what for the DAB that I was on. First of all, of course, you have to have some form of background in both arbitration and mostly in adjudication. Being a lawyer is an added attraction to those who wish to appoint you. But I sat on that DAB with 2 engineers because it was a construction project. And both of them were, of course, adjudicators. The reason they needed me was because of my lawyer background and the fact that I'm also an adjudicator and an arbitrator. So as far as I know, that's some of the credentials that will endear you to people who are looking for members of a DAB. I don't know what your experience is, Karim. Maybe you can add to that.
Yes, so my experience is actually very similar to yours, Ms. Kariuki. I often see the chair of a dispute board being a lawyer, someone from a legal background, who's also an experienced adjudicator and has experience of construction projects. And then the 2 other kind of party appointed dispute board members, if we can call them that, are often engineers or people from an engineering background. Sometimes you see one of them kind of being more on the planning and delay side and the other being more on the quantum side. But it's left to the choice of the parties. But like I say, I very often see lawyer in the chair and then engineers on the party appointed side.
Thank you, Karim. Thank you, Jerry. I have also a question on the delay of rendering the decision. What happens if you have to go beyond the delay started in your adjudication? How is it working? How do you organize the dispute when you have to go beyond the delay? Have you ever experienced that situation in your practice?
Ms. Kariuki,
Karim, go ahead, because delays, no, I guess that's why you have a DAB, so as to ensure there are none. And I think, in fact, Karim referred to it. He says hundreds of millions of dollars are going down the drain when there are these delays. So the whole purpose of a DAB is to ensure that there are none. So Karim, please go ahead.
Yeah, I think it's in a similar vein to what we've already said. I mean, if it all works well, like Ms. Kariuki said earlier, you have something like a standing dispute board who visits the site regularly, sees things that might be causing delay or are going to cause delay, or identifies that the parties are disagreeing on something. Say, for example, they disagree on what standards the design needs to comply with. And if there's a disagreement about design, then in theory, depending on how significant that design is, the contractor may then be unable to progress any work until the design is approved. So in an ideal world, the dispute board visits the site, the parties say, oh, we have this issue about design. Dispute board recognizes this has consequences and has the potential to delay the whole job, and then talks to the parties, hopefully helps them reach an agreement on how this can be dealt with. And then there is no dispute and there is no delay. But, unfortunately, we don't live in an ideal world. But on the dispute resolution side, I think the dispute board is often mitigating or helps mitigate delay because you're deciding disputes quickly and you're also working with the parties to help them deal with that issue as part of the dispute resolution process, in the hope that you're not waiting until the job is complete and the 2 or 3 years of delay have already accrued. You're dealing with things immediately as they occur, and you are deciding who is responsible for what, even on an interim basis. And I think that can help mitigate delays and avoid things getting out of control.
Thank you very much, Karim and Jerry. I don't know if there are other questions in the chat. If not, I will just say thank you to both of you. I learned a lot about dispute boards because I've never been approached to practice, but it's very interesting. I've learned that is a very effective way of solving dispute, but it's very important to pay attention on how the clause is written for enforcement, especially. When the clause is well written, the enforcement will be also easier to carry on. So thank you so much, Karim. Thank you so much, Jerry, for your time. I will just ask the others to join to join the Young AfAA committee. This committee is yours, and we expect you to bring up subjects that can be discussed and so that we can learn together. Thank you so much. And with that, I will close our first AfAA Young Committee webinar of today. Thank you and see you soon.
Thank you.
Thank you so much, Sylvie and Sally.
Thank you.
Thank you very much. Thank you very much.
Thank you.